member states European Convention on Human Rights, that is the European Court of Human Rights. Over decades, the European Court has played a very important role, as we all know, on human rights protection in several areas, fair trial, minorities, Roma, privacy protection, but also on the issue of freedom of expression. So therefore the question, what is the position of the European Court's approach with regard to the issues we are talking about here, journalists working with leaks, investigative journalism, protection of whistleblowers. As a general analysis, you could say that the Strasbourg court used to be on the barricades for better access to public documents, for protection of investigative journalism, journalists using leaks, protection of journalistic sources, and protection of whistleblowers. As a matter of fact, it is thanks to the European Court that we can formulate these four aspects in terms of rights, because the national states were not considering at all or not sufficiently these aspects as being protected under Article 10 of the European Convention, the right to freedom of expression. So the European Court upgraded, uplifted, strengthened these rights through its case law of the last 10, 15 years. A few examples, to go very fast: access to official documents, very weak enforcement in some countries. European Court, after being very reluctant during a very long time, in 2009 decided that the right of citizens, but specifically of journalists and NGOs, to have access to public documents is covered by Article 10 of the European Convention, which means that you can apply, complain in Strasbourg when you don't get access to certain documents in your country. And the court developed the need of access to information, otherwise those who have a monopoly over information have a censorial power. And in two cases in 2009, the court indeed found for the first time in two cases in Hungary violations because the authorities did not guarantee access to certain information. Another recent example, 2013, Youth Initiative for Human Rights wanted access to files that could demonstrate that the intelligence agency in Serbia was monitoring in an illegal way, was refused access to it. Case was taken to Strasbourg. The refusal to give that specific information on request was a violation of Article 10. And to make it serious, the court went one step further, and that's very, very exceptional. It ordered the Serbian authorities to reveal the information within a certain period through the agency and give the information to the NGO at issue. Guseva versus Bulgaria last year, very clear example of a strong right of a journalist and an NGO to be informed on an issue of public interest. It was here not about human rights, but animals' rights. Situation of stray animals in a certain area. The public watchdog role of the media was emphasized here, and the court made clear that the refusal to provide the information hindered a preparatory stage of the process of informing the public. So very clear cases, and also in 2014, a case of Romania, to have access to a budget at the municipality, violation of Article 10 because of the refusal to give access. Very good cases, a pity that the applicants had to go to Strasbourg, but they didn't have the right in their own country. Strasbourg made the difference, and the member states have to follow these decisions by the court because the convention is binding on all member states. Protection of investigative journalism, the case of Le Canard Enchaîné, we had the case of Radio Twist versus Slovakia, cases where journalists were convicted in their country because they had used leaks, confidential information to substantiate their story. European Court found that these convictions were violating Article 10. Journalists should be in the possibility in issues relating to public interest to use that kind of information. Was not recognized at national level. The European Court created an extra layer of protection in some of these cases. The same is true with protection of journalistic sources. You will not find a reference in Article 10 to protection of sources. It was in 1996, the case of Goodwin versus UK, that the court, in a very creative but also a very considerate way, broadened the scope of freedom of expression, including journalists to have a right to protect their sources, that only in very exceptional cases can be restricted. Regardless, the European Court said in later case law, whether the source came to the journalist in a legal or an illegal way, that doesn't matter. There should be source protection. If not, you don't have press freedom. And in many cases, you can see the countries here, Luxembourg, Belgium, the Netherlands, most recently also in Turkey, the European Court overruled actions by public authorities in these states. Convictions of journalists, searches of the newsroom were all considered as breaching Article 10 of the Convention. Some of the most famous cases, Tillack versus Belgium, I think is also well known. This case here in these circles. European Court found that what the Belgian authorities had done, raiding the newsroom and confiscating a lot of material of Tillack, writing precisely on corruption around the European Commission, that such an action was a violation of Article 10. Sanoma case in the Netherlands, where the court made clear that it's not up to the police, neither to public prosecutors, to interfere with the journalist's rights. It's only after a judgment by a court or another independent, impartial body weighing all the interests that an interference can be justified. So a very important procedural guarantee for journalists, which was not existing and still is not existing in many European countries, but it's a European standard due to the European Court of Human Rights. Otherwise, we have a chilling effect if you cannot sufficiently guarantee protection of journalistic sources, as reiterated in the case of Naglia versus Latvia. And then protection of whistleblowers. Very important that in 2008, for the first time, the European Court's Grand Chamber, again in a very creative but very strong way, initiated the protection of whistleblowers in a case against Moldova, where a person was dismissed because he leaked a letter which revealed some kind of corruption between the public prosecutor's office and a politician. The dismissal, according to the European Court, was a violation of Article 10 of the Convention. And the court took into consideration a set of criteria where you can discuss about, but anyway, applying this criteria gave a high level of protection to the whistleblower in casu. And we have discussed here last year the confirmation, because there have been many cases now on whistleblowers, and in most of them the court found violations. That means that the member states did not respect the right of whistleblowers, which they have under Article 10. Another example we saw also last year, here the case of Bucur and Toma, an employee of the military unit of the Romanian intelligence service, was dismissed because he had leaked even ultra top secret information. Well, that was the right of that whistleblower according to the European Court because of the public interest involved, and the criteria were followed. In other areas, a journalist writing a book on censorship in Hungary was protected as a whistleblower, and in a case recently against France, where a lawyer, not totally a whistleblower you could say, he gave an interview about ill practices at court in Paris. So he was also a kind of a whistleblower. He was convicted for defamation, but the European Court said, as you can see, a lawyer should be able to draw the public's attention to potential shortcomings in the justice system. The judiciary may benefit from constructive criticism. So it's quite another voice that we hear from Strasbourg, very strongly protecting all the aspects we are talking about. For those who want more background, because this is really very fast, and Gil will stop me after a few minutes, who want to know more about these developments, very recently a book has been published by the Council of Europe on these issues, and there's a chapter with all the information for further analysis. The question is, what is the position of the court today, 2015, 2016? Is the court still on the barricades of press freedom, protection of whistleblowers, protection of journalists as it was? Second part of my presentation, very briefly, I would like to refer to some worrying trends that I see in some recent case law. For instance, access to information. We thought journalists and NGOs had a strong right due to the case law of the European Court. Well, last year, a case in Germany, a German online journalist who wanted a compilation of a list of payments by Wuppertal City to political parties that was refused at all levels in the German judiciary system. He goes to Strasbourg, and all at once we can see that Strasbourg court becomes more reluctant. It says all at once, we cannot construe from Article 10 an obligation of states to have positive obligations to collect and disseminate information on its own motion while it was on request. There is not a general obligation, and even if Mr. Weber was a journalist, the court said there's no interference by refusing access to information. I think this is a scaring decision, which is not in line with the other jurisprudence of the court. What is happening? Second example, working with leaks. We saw cases where the court very clearly had stated that working with illegal leaks is possible under certain circumstances. Well, there's a Grand Chamber judgment of only a few months ago, Beda versus Switzerland, in which a journalist was reporting on a very serious crime, 3 people killed, many injuries, what led to a criminal case in Switzerland. And he had access to some documents from the criminal case, criminal files. He was convicted in Switzerland because of disrespect of the secrecy of the judiciary. He goes to Strasbourg, and the Strasbourg court says, as a responsible journalist, you should not reveal information which belongs to the judiciary. I think this is, again, a step backwards. And the court said, as a professional journalist, he must have been aware of the confidential nature of the information which he was planning to publish. What is this? European Court of Human Rights is of the opinion that journalists who are aware of the confidential nature of information should refrain from reporting and publication. Second worrying case. Third worrying case, case of Salihu versus Sweden. Check it out, journalism. There were a few cases in Malmö, south of Sweden, abuse and use of illegal weapons. Some people were killed. Journalists want to investigate, is it possible, is it so easy also in Sweden to get illegal firearms? They check it out, they have their program broadcasted, or they have in this case the article also published, and they are convicted in Sweden for wearing illegal firearm. They go to Strasbourg, and the Strasbourg court said, yes, you have breached the law, even if it was in the public interest. Interesting story, but you have breached the law, and you should be convicted. Because you could have made your story in another way. From the moment you knew that you could get illegal fire weapon, there you should have stopped and not buy it yourself. Is the European Court trying to influence the techniques of journalistic reporting in such a far-reaching way? Question mark. Boris Erdmann versus Germany, a recent case, documentary broadcasted on Pro7, in which Mr. Erdmann checked out the security in several German airports. And he succeeded in several to enter with a big knife into the airplane. And he took photos, and with a hidden camera, he could document it. He was prosecuted and convicted in Germany because of breach of rules to bring dangerous objects in an area where they are not supposed to be. European Court is of the opinion, again, he committed a criminal offense, and the fact that it contributed to an issue of public interest is not sufficient to find a violation of Article 10. So also a worrying approach. Again, the court said that he could demonstrate that in another way, and I should have stopped earlier, not bringing the knife in the airport. But yeah, what have you demonstrated then? Protection of journalistic sources. A recent case against Turkey. Good, the European Court found a violation. The magazine Nokta, which is famous for this cover, but the case has nothing to do with this. And the essence was that Nokta had published a document from the military that excluded some media from coverage on military operations. Clear violation, the searching of the newsroom of Nokta. But what can we read in one of the considerations of the European Court? That journalists should only publish information from whistleblowers after the whistleblowers have used all internal procedures. You have to wait as a journalist, that you have to be sure that all the procedures have to be followed. I think this is a strange way of approaching. It looks like the European Court is expecting in the future that journalists can only work with legal leaks. We had LuxLeaks, Swiss leaks, Panama leaks, and now there's only legal leaks. And protection of whistleblowers, we thought this was acquired. Then there came last year this decision by the European Court, September 2015, in a case of whistleblowing, where the court mainly stresses that the allegation of corruption after an investigation was found unfounded. And I think that should not be a requirement to protect whistleblowers, but it can happen that there are indications of corruption and fraud, and that after a serious investigation, there's no reason for a criminal case. But still, that should not be the reason to deny whistleblower protection in such a case. So yes, some worrying developments. I can also see that the case law, the former case law of the court, strongly guaranteeing these rights, has not much impact at domestic level. We had the case of Del Tour, the case of Falciani in Switzerland. Protection of journalistic sources is under attack in many countries, so it seems that also the case law of the European Court is not enough to protect us, especially in the framework of anti-terrorism. Access to information is more and more restricted. Investigative journalism is under threat. Illegal leaks are no longer protected by protection of journalistic sources, and there is no sufficient protection of whistleblowers. We don't reach the level of protection the European Court requires. Last slide, because apart from making the analysis, we also want to look what can we do about it. I see three possibilities where this network needs to create awareness or react. First of all, we need a better monitoring by media, by journalism, by the academic world. Maybe I heard somebody this afternoon, he said I'm an activist journalist. Well, I'm an activist academic then. To explore these things, to monitor and to bring them under the attention of the broader public, politicians, lawyers, judges, and so on. Role of this network. Secondly, I think we should interfere with third-party interventions at the level of the European Court, that some of these worrying trends will not be repeated, or that in new case law, the court again will find the right track it was on before. And here I think ECPMF is already playing a role, together with some of our partners, MLDI, Article 19, our Legal Advisory Committee, some NGOs, to support journalists who got in trouble in their own country and bring their case to the European Court. We have for the moment very recently supported two cases, Butkovic versus Russia and Surovic versus Hungary, which had to do with the refusal of a journalist to give access to a refugee camp to report on that. Third, I think we need a dialogue with the European Court of Human Rights. The few examples I have given are worrying. They should create concern amongst the human rights networks. and we need a dialogue with the judges of the European Court. And that's why ECPMF is, for the moment, preparing a conference in spring 2017 to have a dialogue in Strasbourg with the judges, what is going on these issues. You had such a good record, Strasbourg, in protecting these 4 levels, and now it seems to flow away. Can you please explain us, if possible? If not, get back on the track where you were. It's a pity, I would say, that the Fundamental Rights Agency is not participating, but we have a broad coalition of partners in organizing this conference. So that was my message. Thank you for not interrupting, Gil. Thank you.